Hey everyone. Sorry, we've just been having some technical issues with the sound. Sorry for any inconvenience. I'm so sorry, everyone. We will resume again now I'm speaking. Of course, the webinar will be running for a little bit longer. Really apologies for the technical issues that we've been having this morning. Okay, so I'd like to draw your attention to the chat box on the screen. If something is unclear to you during the webinar or you'd like further clarification on anything mentioned today, please feel free to submit your questions. And I'd be happy to elaborate by responding to you via the email that you used to sign up. If you'd like more information about any judgment or ruling, looking at the case law will give you a really in-depth overview. So I've put the cases in bold, as you probably saw from the slides, throughout the presentation. I'd recommend taking a note of them to look them up later. So I will be maybe speeding through it a little bit quickly just to make up some of the time that we've lost. But we will be starting from the beginning, so I can just explain what's on the screen to you. So this is today's agenda. And I started by talking about intellectual property, how it describes a wide variety of property created by musicians, authors, artists, and inventors. It's intended largely to encourage the development of art and science and information by granting certain property rights to all artists, which include inventors in the arts and science fields. These rights allow artists to protect themselves from infringement or the unauthorized use and misuse of their creations. Trademarks and service marks protect distinguishing features such as names or package designs that are associated with particular products or services and that indicate commercial source. Intellectual property is protected in law, for example, by patents, copyrights, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the intellectual property system aims to foster an environment in which creativity and invention can flourish. There are more specialized or derived varieties of exclusive rights, such as circuit design rights and database rights in European law. However, today we will be discussing just the main types of copyright, patent, and trademark. So while trademark law seeks to protect indications of the commercial source of products or services, patent law generally seeks to protect new and useful inventions. And registered designs generally seek to protect the look or appearance of a manufactured article. Trademarks, patents, and designs collectively form a subset of intellectual property known as industrial property because they are often created and used in an industrial or commercial context. So the Statute of Monopolies in 1624 and the British Statute of Anne in 1710 are seen as the origins of patent law and copyright, respectively, firmly establishing the concept of intellectual property. So the Statute of Anne was actually was the first statute to provide for copyright regulated by the government and courts rather than by private parties. So until recently, the purpose of intellectual property law was to give as little protection as possible in order to encourage innovation. Historically, therefore, they were granted only when they were necessary to encourage invention, um, limited in time and scope as well. So copyright is a legal term used to describe the rights that creators have over their literary and artistic pieces. Works covered by copyright range from books to paintings, sculpture and film, to even computer programs, maps, or even technical drawings. So Kendrick and Lawrence in 1890 was an influential English case on the nature of copyright. In it, the court establishes the extent for which copyright protection is given for a work and at which point it crosses the line from expression, which is protected, to an idea, which of course is not. The company in the case held the copyright of the drawing of a hand holding a pencil and drawing a um, check marks into a box. And this drawing was used on voter cards to help illiterate to how to vote. A rival company produced a card with a similar but not identical drawing of a hand drawing a check mark into a box, and they were sued for copyright infringement. So the court detailed about how accurate an imitator must be to constitute copyright infringement. The court characterized the claim as a claim to the subject matter itself. However, the defendant claimed, on the other hand, that only an exact reproduction could be protected. In this case, the court took the middle ground, ruling that the greater the labor and skill invested into the work, the broader protection will be granted, while simpler works, such as a check mark in the box, will receive narrower protection. Copyright is a legal right created by the law of a country that grants the creator of an original work exclusive rights for its use and distribution as well. So this typically is only for a limited period of time. Characteristically, the duration of a copyright spans the author's life plus 50 to 100 years. So that is a copyright that typically expires 50 to 100 years after the author dies, depending on the jurisdiction. So some countries require certain copyright formalities to establishing copyright. However, most recognize copyright in any completed work without formal registration. So territorial rights, while many aspects of national copyright laws have been standardized through international copyright agreement, laws vary by country. So some countries do not require that a work be produced in a particular form to obtain copyright protection. So for instance, Spain, France, and Australia don't require fixation for copyright protection, while the US and Canada require that works must be fixed in a tangible medium of expression in order to copyright protection. US law requires that the fixation be stable and permanent enough to be perceived, reproduced, or communicated for a period of more than transitory duration. So, long lasting, essentially. And similarly, Canadian courts consider fixation to require that the work be expressed to some extent, at least in some material form, capable of identification and having a more or less permanent endurance. So is often shared among multiple authors, each of whom holds a set of rights to use or license the work, and who are commonly referred to as rights holders. So these rights frequently include reproduction, control over derivative works, distribution, public performance, and moral rights such as attribution. So the exclusive rights are not absolute, but limited by limitations and exceptions to copyright law, including the fair use doctrine. But we will have a look at this in more depth in just a few slides. So, fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of copyright protected works in certain circumstances. So, Section 107 of the Copyright Act provides the statutory framework for determining whether something is a fair use and identifies certain types of use, such as criticism, comment, news reporting, even research. These are examples of activities that may qualify or constitute as fair use. So, most jurisdictions recognize copyright limitations, allowing fair exception to the creator's exclusivity of copyright and giving users certain rights. So, as well, this is very common in universities and schools. So, the development of digital media and computer network technologies have promoted reinterpretation of these exceptions and introduced new difficulties in enforcing copyright and inspired additional challenges to copyright law's philosophic basis. To simultaneously, businesses with greater economic dependence upon copyright, such as those in the music business, have advocated the extension and expansion of copyright and sought additional legal and technological enforcement. So Hawks and Son London Limited and Paramount Film Service Limited talks about an infringement of copyright that occurs only when a substantial and vital or essential part of a work is copied. So another major limitation on copyright is that the copyright protects only the original expression of ideas rather than the underlying ideas themselves. And this was established in Giles and Wilcox. So the case set a legal precedent which has shaped copyright law to the present day. It established the common law doctrine of fair abridgment, which was cited in other cases, ultimately building up to the idea of fair use. So the opinion also recognized the author's right to a work through the nature of the labor it took to produce it, shifting copyright away from publishing rights and towards the idea of serving the greater good by encouraging the production of new and useful pieces of work or in inventions as well. The development of digital media and computer network technologies have prompted reinterpretation of these exceptions. They've introduced new difficulties in enforcing copyright and inspired additional challenges to copyright law's philosophic basis. Simultaneously, businesses with greater economic dependence upon copyright, such as those in the music industry, have advocated the extension and expansion of copyright and sought additional legal enforcement. Copyright protection across the world has become more difficult in recent years due to the technological advances that make content sharing extremely easy and inexpensive, and due to a drastic increase in the utilization of internet-related platforms such as social media. Since the dawn of internet age in the late 1990s, legislators around the globe have been trying to determine how to balance the need to protect an author's intellectual property from unauthorized use without hampering innovation. The UK Digital Act regulates digital content in the United Kingdom. The UK DEA provides the government broad power to suspend, limit, or terminate internet service to copyright infringers. Another major limitation on copyright is that copyright protects only the original expression. So this, of course, is difficult for to receive adequate protection when things are so easily replicated online now. We're going to look at patents now. A patent is an exclusive right granted for an invention, which is a product or process that provides, in general, a new way of doing a solution to a problem. So to get a patent, technical information about the invention must be disclosed to the public in a patent application. So in other words, patent protection means that the invention cannot be produced on a commercial level, used, distributed, imported, or sold by others without the patent owner's consent. The procedure for granting patents requirements placed on the patentee and the extent of the exclusive rights vary widely between countries according to national laws and international agreements. Typically, however, a granted patent application must include one or more claims that define the invention. So a patent may include claims, each of which define a specific property right. The claims must meet the relevant patentability requirements such as novelty, usefulness, and non-obviousness as well. So the exclusive right granted to a patentee in most countries is the right to prevent others, or at least to try to prevent others from commercially making, using, selling, importing, or distributing a patented invention without permission. From an economic and practical standpoint, however, a patent is better and perhaps more precisely regarded as conferring upon its proprietor the right to try to exclude by asserting the patent in court, for many granted patents turn out to be valid once their proprietors attempt to assert them in court. So a patent is limited property right the government gives inventors in exchange for their agreement to share details of their invention with the public. Like any other property right, it may be sold, licensed, mortgaged, transferred, given away, or simply abandoned. A patent being exclusionary right, it does not necessarily give the patent owner the right to exploit the invention subject to the patent. So, for example, many inventions are improvements of prior inventions that may still be covered by someone else's patent. So, if an inventor obtains a patent on improvements to an existing invention which is still under patent, they can only legally use the improved invention if the patent holder of the original invention gives permission, which they may refuse as well. So the duration of a granted patent is 20 years, counted from the date of filing. So this is the date which the patent application was officially received and filed. So where priority from an earlier application is claimed, it's still the filing date rather than the priority date, which is relevant for the calculation of the 20-year term. So in some circumstances, it may be possible to get an extension of protection for a specific product covered by a granted patent, which will extend the term of protection above the 20-year mark. This is referred to as a supplementary protection certificate. The trademark or trademark is a distinctive sign or indication used by an individual or legal entity to identify that the products or services with which the trademark appears originate from a unique source. It serves to distinguish its products or services from those of other entities. And trademarks date back to ancient times when craftsmen used to put their signature or mark on their products. So a trademark may be labeled by the following symbols. The TM sign is used to signal an unregistered trademark indicating a brand name for a product. And this sign can be designated by the owner indicating their belief of the trademark. The symbol TM is used to provide notice of a claim of common law rights in the trademark. It's usually used in connection with an unregistered mark to inform potential infringers that a term, slogan, logo, or other indicator is being claimed as a trademark. So use of the TM symbol does not guarantee that the owner's mark will be protected under trademark law. However, the owner may continue to use TM should registration of the mark be refused. So you'll be able to stop somebody using a similar trademark to yours on their goods and services if you haven't registered it yet. So you'll need to usually get legal advice from a trademark attorney or solicitor. It's hard. It's more hard actually to prove passing off than it is to defend a registered trademark. So to be successful, you'll need to show that the mark is your own and that you built up goodwill associated with the mark, that you've been harmed in some way by the other person's use of the mark. So while TM can be used with any common law usage of a mark, the R symbol may be used by the owner of a mark following registration with the relevant national authority. The R symbol um, can only be used once it has been registered by a country, entity, or any organization as well. This indicates that the country authority has approved the registration officially. You can register your trademark to protect your brand, i.e., the name of the product or the service that you've created. So when you register the trademark, you'll be able to then take legal action against anyone who uses the brand without your permission, including counterfeiters. You'll be able to put the R symbol next to your brand to show that it's yours and to warn others against using it. And this will also be used to sell and license your brand. So the essential function of a trademark is exclusively to identify the commercial source or origin of the product or service. So a trademark indicates the source or serves as a badge of origin. It should be noted that trademark rights generally arise out of the use of to maintain exclusive rights over that sign in relation to certain products or services. And once trademark rights are established in a particular jurisdiction, these rights are generally only enforceable in that jurisdiction, a quality which is sometimes known as territoriality. So, however, there is a range of international trademark laws and systems which facilitate the protection of trademarks in more than one jurisdiction, but we will look at that in just a few slides. So trademark distinctiveness is an important concept in the law governing trademarks and service marks as well. A trademark may be eligible for registration if it performs the essential trademark function and has distinctive character. Distinctive character of trademarks was discussed and established in extremely recent UK intellectual property case of Kit Kat and Cadbury. So can the shape of the Kit Kat chocolate bar be registered as a trademark on grounds that it has acquired distinctiveness through its use over the years? So what is required to prove that a trademark has acquired distinctiveness through use? Um, so in this case, it was found that the trademark must be understood as referring solely to the use of the mark for the purposes of identification by the relevant class of persons of the goods or services originating from a given undertaking. So it is in consequences of such use that the relevant class of persons actually perceive the goods or services designated exclusively by the mark applied for as originating from given undertaking, although the trademark for which registration is sought may have been used as part of a registered trademark or in conjunction with such mark. So the fact remains that for the purpose of the registration mark itself, The trademark applicant must prove that the mark alone, as opposed to any other trademark, which may also be present, identifies the particular undertaking from which the goods originate. So for this particular case, the sign for the registration was sought corresponded to the shape of the four-finger Kit Kat product, except it lacked the Kit Kat logo, which was embossed onto each of the fingers of the actual product. So following a reference for preliminary ruling to the court, the case got back to the High Court of England, with the judge applying a ruling that has raised more than an eyebrow and looks fairly ambiguous. So this is particularly with regard to what is needed to prove acquired distinctiveness of a trademark. So the procedure for international trademark registration is a fairly simple one. Companies and individuals alike may apply as long as their country of origin belongs to the agreement or protocol, as well as any legal entity domiciled or having a real and effective industrial or commercial establishment in a country belonging to either treaty. The Madrid system is run by the International Bureau of the World Intellectual Property Organization in Geneva. However, it's not commonplace to directly file an application with the WIPO. This purpose is to register a trademark simultaneously in as many countries as the applicant chooses from the list of members of the protocol. So when the international application is filed, the applicant must designate the countries in which he wishes to seek protection. So alternatively, the application is directly filed with the respective national trademark office, which is then sent on to Geneva after conducting checks to ensure all details coincide with those of the national mark on which it is based. And the cost of registering a trademark, um, it varies depending on your office location of origin, the number of classes, and the type of mark required. So the WIPO website has a fee calculator that you may use to calculate any costs associated with the registration. And you can find the calculator link here on screen. But if you'd like to leave your email in the chat box, I can send you the link for the calculator. The trademark rights must be maintained through actual lawful use of the trademark. These rights will cease if a mark is not actively used for a period of time, which is normally 5 years in most jurisdictions. In the case of a trademark registration, failure to actively use the mark in the lawful course of trade or to enforce the registration in the event of infringement may also expose the registration itself to become liable for an application for the removal from the register after a certain period of time on the grounds of non-use. So it's not necessary for trademark owner to take enforcement action against all infringement if it can be shown that the owner perceived the infringement to be minor or inconsequential. So this is designed to prevent owners from continually being tied up in litigation for fear of cancellation. An owner can commence action at any time for infringement against a third party, as long as notification of wrongdoing was not provided and then failed to take action within a reasonable period of time. The owner can always reserve the right to take legal action until a court decides that the third party had gained notoriety, when the owner must have been aware of it. It will be for the third party to prove their use of the mark is substantial, as it is the responsibility of a company using a mark to check that they're not infringing any previously registered rights. So in the US, owing to the overwhelming number of unregistered rights, trademark applicants are advised to perform searches not just on the trademark register, but also in the local business directories and relevant trade press. So all jurisdictions with a mature trademark registration system provide a mechanism for removal in the event of such non-use, which usually is a period of 3 to 5 years. The intention to use a trademark can be proven by a wide range of cases, but we will look at the Woolly Bull Enterprises Pty Limited and Reynolds case. So as we discussed a little bit previously, we'll look at it in more depth now. So the WIPO is the Global Forum for Intellectual Property Services, policies, information, and cooperation between different countries. It's an agency and a partner of the United Nations. It was introduced in order to lead the development of a balanced and effective international property system that enables innovation and creativity for the benefit of all countries globally. So our mandate, governing bodies, and procedures are set out in the WIPO Convention, which was established in 1967. So it currently has 188 member states or countries that internationally recognize it. And the Madrid system is a one-stop solution for registering and managing marks worldwide. So you file one application in one language, you pay one set of fees to protect your mark in the territories, and you manage your portfolio of marks through one centralized system. So the treaties WIPO administers together with national and regional laws make up the international legal framework for trademarks. So here are a few of the most prominent trademark-related treaties around the world currently administered by WIPO. But we will discuss the Madrid Convention on the International Registration of Trademarks. It concluded in 1891, so a really long time ago. The system makes it possible to protect a mark in a large number of countries, not just in Europe, by obtaining international registration that has effect in each of the designated contracting parties. The Madrid Agreement was originally intended to provide for a convenient, cost-effective, and international registration system, which has done effectively. However, there were a number of criticisms limiting the agreement's success. So the lack of international acceptance. Of course, there are a lot of members. However, there are also many non-member countries who are not keen to sign up to the regime, which of course undermined the system as being a truly global one. Many of the countries who did not join um, represent some of the largest numbers of the trademark filings and registrations globally. So the current system of forwarding by the International Bureau to member jurisdictions rather than just registering the applicable trademark stops an actual registration system currently. They are working continuously to improve the system for users. So essentially, if you are wanting to protect yourself on an international level, you can use this system, or alternatively, you can file a trademark with the trademark office of each country in which you are seeking protection. So we'll do a really quick Q&A of some of the most common question and quick answers regarding intellectual property. So when you have developed an invention, it's important to keep this confidential. So any disclosure of the invention prior to filing a patent application may compromise the ability to get patent protection on the invention. So before assessing whether you should consider patent also look at the commercial value of the invention. So an important consideration is whether the invention is actually patentable. The main requirement for patentability is novelty, which requires that the invention has not been made public by yourself or another in any other way. So very often the inventor is very much aware of the scientific literature in the field of his invention. A lot of information is, however, published only in patent documents. So it's also important to consider the type of publications. So in order to be patentable, the invention must also comply with the requirement of inventive step. And it should be possible to describe the invention in a way that can be carried out by a skilled person. So it's essentially as long as the cost to create the patent does not outweigh the value that it will be bringing to you as well. This is obviously a really important consideration to make. Can you get rights to someone else's patent? In some cases, the patent owner will only allow third party to use his patented invention for a remuneration or other financial compensation. This will usually be formalized in the form of a license agreement. So, in a license agreement, a number of conditions can be specified. So, you can um, specify exclusivity, scope of use, duration, territorial scope, and license remuneration. So, how much you want to charge for someone else to use it. Licenses are preferably drawn up by a lawyer or attorney specializing in intellectual property matters in negotiations directly with the patent holder. And what are the most common mistakes when applying for a trademark? A common mistake that companies make sometimes is failing to ensure that they are the owner of a mark before applying in um, other countries. So before extending your mark, you should make sure that you have a clearly established ownership. So because filing rights are based on what the trademark is actually used for, you also should make sure to think through the current purpose of the brand name and what you may want to use it for in future. So, for example, if you're filing for the name of a handbag and are planning to later apply the name to jewelry, you should plan for this in the branding strategy. So make sure that you can think through what the future lines of commerce for those marks will be, and then make sure that you prove that you're using the mark in your application. And this is actually a requirement in the UK. So as mentioned earlier, translation in the market you're using can be a potential pitfall. You can mark it can be translated into something you don't want, or there can be bad cultural connotation. So ensure to check all of the translations thoroughly. So the copyright holder is typically the work's creator or a publisher or other business to whom the copyright has been assigned. Copyright holders routinely invoke legal and technological measures to prevent and penalize copyright infringement. Copyright infringement disputes are usually resolved through direct negotiation, a notice, and a takedown process or litigation in civil court to do so. So, severe or large scale commercial infringement, especially when it involves counterfeiting, is sometimes prosecuted via the criminal justice system. So, shifting public expectations, advances in digital technology, and the increasing reach of the internet have led to such widespread anonymous infringement that copyright department industries now focus less on pursuing individuals who seek and share copyright protected content online and more on expanding the copyright law to recognize and penalize as indirect infringement. Service providers and software distributors, which are said to facilitate and encourage individual acts of infringement by others. So a derivative work is an expressive creation that includes major copyright protected elements of an original previously created work, and this is the underlying work. So the derivative work becomes a second separate work, independent in form from the first type. So the transformation, modification, or adaptation of the work must be substantial and bear its author's personality to be original, and therefore protected by copyright. So translations, cinematic adaptations, and musical arrangements are common types of derivative works. Most countries' legal systems seek to protect both original and derivative works as well. They grant authors the right to impede or otherwise control their integrity and the author's commercial interests. So derivative works and their authors benefit in turn from the full protection of copyright without prejudicing the rights of the original work's author. So typically a party other than the patentee or licensee that manufactures, imports, uses, sells, or offers for sale patented technology without permission or license from the patentee during the term of the patent and within the country that issued the patent is considered to infringe it. So the test varies from country to country, but generally it requires that the infringing party's product falls on one or more of the claims of the patent. So the process employed involves reading a claim onto the technology of interest, and if all of the claims elements are found within the technology, the claim is said to read on the technology. So if a single element from the claim is missing, the claim does not literally read on the technology, and the technology generally does not infringe the patent with the respect to such claim, except if the doctrine of equivalence is considered applicable. So in response to allegations of infringement, an accused infringed party typically asserts one or more of the following defenses. That it was not practicing the patented invention, i.e. the invention claimed in the patent. Um, the claims defined the extent of protection conferred by a patent. That it was not performing any infringing act in the territory covered by the patent, that the patent expired, since patents have a limited patent term, i.e. a limited lifetime, that the patent or the particular claims alleged to be infringed is valid because the invention in question does not meet the patentability requirements or includes a formal defect. So this is rendering the patent invalid or unenforceable, and that it obtained a license under the patent as well. So the parties may also resolve their dispute in a settlement, which may involve a licensing agreement, such as a cross-licensing agreement. And these private settlements may not always serve public interest because litigating patent disputes to completion tends to generate positive externalities. So by clarifying the limits of patent protection if the patent is upheld, or encouraging wider use of the innovation if the patent is invalidated. So trademark infringement is a violation of exclusive rights attached to a trademark without the authorization of the trademark owner or any licenses, provided that such authorization was within the scope or of the license. So infringement may occur when one party uses a trademark which is identical or confusingly similar to a trademark owned by another party. And I'm sorry, I would really love to go into depth here about all of the different um, parts of the likelihood of confusion, but these are just general. So just look at them here. I have to go through. So sorry for the rush and for the technical difficulties at the beginning. So that concludes the webinar for today. Thank you everyone so much for participating and submitting your questions and letting me know in the chat box when there was something wrong with the sound. So you can find recordings of today's webinar at eltoma-global.com. I don't know if you would like to send a version that I'm able to go into a bit more depth about some things. If you would like, just request, that's no problem at all. So as well, you can also submit any future webinar topics that you would like to attend. So thank you everyone and enjoy the rest of your day.